Hello, it's Kuldeep Clair. I'm going to be talking about the situation in the UK in terms of employment law, particularly with regard to redundancy law, and in relation in particular to the coronavirus crisis and the large-scale redundancies which are going to be happening and are happening and starting to happen at the moment already. As a result of the very unfortunate turmoil that has occurred in the world as a result of the COVID-19 issue. Obviously, it's had a dramatic impact on the economy of this country, and many people have lost their jobs. Many people have been furloughed under the Coronavirus Job Retention Scheme, CJRS, and as a result of the CJRS coming to an end, which will be happening on the 31st of October, that will mean that many more employees will be made redundant from their positions. I'm going to look at the position both from the point of view of employers, what they can do in terms of making sure that any redundancy is dealt with fairly and properly in accordance with law, and from the point of view of employees. And it will be very useful for both employees and employers, this quick talk on what your rights are, what you're entitled to, and what the redundancy process should amount to, and a key summary of what that process should be. So, from the point of view of employers, first of all, what can you do to make an employee lawfully redundant? How should you go about the redundancy process, and what are the consequences of doing it wrongfully? From the employee's viewpoint, what is your entitlement if you are an employee and you believe that you have been made redundant perhaps fairly, or if you've been made redundant unfairly? How do you know that? What should you look out for? How would you bring a claim? How do you go about bringing a claim? What's the time limit for bringing a claim? And what do you need to do? Even the answers to those simple questions. Sometimes people think they know the simple answers, but they're a little bit complicated. One question that some people have asked is, can furloughed workers who have been furloughed be made redundant at all? Is there something about the fact that they've been furloughed which makes them immune from redundancy? Well, it's an interesting question. After all, the CJRS is described as the Coronavirus Job Retention Scheme. So you might think that if you've been furloughed, you're sort of immune from redundancy for quite a while. But that's not the case. An employer can still choose to make you redundant afterwards once the furlough period has ended, whenever that may be, after the agreed furlough period, and you're subject to redundancy in the same way, subject to the same laws and principles as any other employee, even if you weren't even employees who weren't weren't furloughed. So, how should an employer approach redundancy? What are the key points in a fair, lawful redundancy process? A redundancy process should be fair, it should be reasonable, and it should be lawful. Those are simple phrases, can be very difficult to apply in practice. We've got to go back to the statutory definition of redundancy. What is a redundancy? The situation at the workplace must amount to a statutory definition of redundancy. Even the statutory definition, because it's applicable in so many different situations, can get a bit complicated. To try and explain it in as few words as possible, I would use the following kind of definition. I would say that a redundancy is where there is a reduced need by the employer for employees to do work of a particular kind than there was previously. And now, given the economic turmoil that has occurred, it could be said that is going to be quite easy to demonstrate for many employers at the moment, given what has happened in the last few months, particularly in certain sectors within the economy. And the next thing to look at, that employers need to look at, is that when they're making employees redundant, they need to be very fair in the selection process. So the selection process is the next thing that needs to be very fairly looked at. The way in which employees are selected for redundancy needs to be very objective. You've got to use objective criteria for selecting employees. You've got to use, the first task is to pick a pool of candidates for selection using certain criteria, and then you can use certain criteria to whittle down that pool in a fair way to those employees that are required to be made redundant. How large should that pool of employees, that initial pool, be? What are acceptable criteria? Different answers in different situations. There's no easy answer. In broad terms, the criteria must, as I've said already, be objective. That means they must be objectively accessible by other people other than the immediate manager who's making those decisions about redundancy. The criteria must not be purely arbitrary. Obviously, there should be no discrimination of any kind against people with protected criteria, against any employees with protected criteria, against women, ethnic minorities, those of a particular religion, or those of a particular age, as well, and other things as well. And that raises an interesting issue, actually, because it was traditional to use one criteria known as the LIFO principle, which was last in, first out, as a guide to making people redundant. And what that meant was that those who joined the company last were the first to be asked to leave, in terms of using that as a selection mechanism. That's being increasingly frowned upon now, actually. The law is changing a little bit. That used to be regarded as easily acceptable. That's not so much anymore. And guess why? Because it indirectly discriminates against those of a certain age. And that's not really right. So even the law is changing as time goes on. So your decision on which criteria to use must be looked at very carefully, and it's a good idea to get expert advice on it. The other important point is that there must be a consultation process. The consultation process must be a fair and objective one. It must be a real one. It must not be just a sham. It must not be just a robotic exercise that's gone through just for the sake of it. It must be meaningful, and I would say, in my humble opinion, that a consultation period must last at least a good 4 weeks for it to be described as meaningful. You must have meetings with the employee or employees who were initially selected for redundancy. And those meetings must be meaningful, and discussions must take place. It's rare that an employment tribunal would regard any consultation as being completely unnecessary. They're always regarded as useful and effective and necessary. So if you don't have consultations, it's going to add to the potential likelihood of the redundancy process being found to be unfair. In general, I would say that it's quite likely that if you don't take professional advice in your redundancy process as an employer, you're going to fall foul of the law at some point or another. Now that could be very dangerous. And similarly, if you're an employee, it's quite possible that if your employer doesn't deal with the process properly, you could well have a good claim as well. On the employer's side, you may possibly get things wrong and you may get away with it because the employee may not be bothered to take a claim or may not be aware of the fact that he or she has a claim. These are just risks that you're going to be taking if you don't take proper professional advice from someone like me. If you're an employee and you do have a potential claim, the usual time limit for bringing a claim after the termination of your employment is 3 months. Within that time, you must present your initial ACAS conciliation application, early conciliation application, and then shortly after that, you must bring your tribunal application to the tribunal as well. Those time limits can be extended occasionally, but you mustn't rely upon getting an extension there. It's very difficult to get an extension. And we can go in, I'll probably be doing another video soon on a bit more on the tribunal process, but I think that's enough for now. Please arrange for a consultation with me if you want to discuss any issue in relation to redundancy. And obviously settlement agreements are a good route out to agree a settlement with an employee and to do so safely and to make sure that there is not going to be an employment claim for an unfair redundancy or anything else afterwards. That's always a very useful route for employers to use, and it's helpful in many other ways in terms of the terms that you can put in a settlement agreement. Please give me a call or get in touch at my email address if you'd like to have a consultation on any employment law issue. Thank you.